welcome to Legal Breakdown, where we break down legal topics to make the law relevant and accessible to everyone. I'm your host, Erin Brueche. My guest today is an expert in divorce and family law. Here to answer some frequently asked questions is Stacey Cozewith. Stacey, welcome to Legal Breakdown.
Thank you.
I am so excited for this topic today because FAQ section is where I go on every website first to kind of get a lay of the land. And I'm sure these are questions you get all the time. But before we get there, I'm really interested to hear a little bit about you and how you got to where you are today.
Well, thank you for having me, Erin. I was born and raised in New Jersey. I went undergrad to Johns Hopkins University in Baltimore, leaving for a bit. And it was there that my interest in family law was sparked when I worked for the domestic violence clinic and helped victims. I continued that work in law school at Rutgers Newark, and then clerked for family law for the Honorable Thomas H. Jilts, who's the presiding judge of the family part. And I really solidified there my desire to work in family law, continuing in the legal sector after my clerkship at Weinstein, Snyder, Lindemann, Sarno. And I left there in 2009 with my current partner, Angelo Sarno. And we have 4 offices and over 25 attorneys, and I practice family law exclusively. I help people with issues of custody, child support, domestic violence, prenuptial agreements, alimony, all financial issues, and I help them mediate their matters, resolve them, and litigate their matters, helping them come to a quick and hopefully amicable resolution.
Well, you are a true expert in divorce and family law, so this is going to be like a little pop quiz today, testing your knowledge, and I'm sure these are questions you get over and over and over again, and if someone has this question, you better believe so many other people have these questions too. So I want to get right to it, and these are a mix of viewer questions, some questions that I've dealt with in my own practice, and some questions submitted from friends and family. So
Sounds
are you
good.
ready?
I'm ready.
Okay.
Let's go.
All right. So first question, what are the grounds for divorce in New Jersey?
Well, we are very thankful that we have a no-fault ground, and that is because people don't have to allege terrible things about their spouse to get a divorce. You can get a divorce on grounds of no fault, which means that you had irreconcilable differences for a period of 6 months, and that it is unreasonable to continue to be married to one another with no reasonable prospect of reconciliation. That's all you have to certify to in order to get a divorce. There are fault grounds, including habitual drunkenness, extreme cruelty, separation for over 18 months, and I can go on, but the main thing and that most people allege is a no-fault divorce.
When would you allege a fault ground? What would be a situation?
Sometimes it's beneficial in a case where the fault is incident to one of the major issues. For example, if there's real issues with regard to custody and parenting time, and there's it's because one spouse is not acting in the best interest and is an alcoholic or a drug addict, or extreme cruelty is the real factor, or if you have been separated for 18 months, that's basically a no fault as well. But like I said, most cases, you want to get divorced, no fault.
Okay, so follow-up question to that. Someone writes, I can't afford to live apart from my spouse right now. Does that prevent me from getting divorced? Does that?
It does not, and they are certainly not alone. This happens in many cases. In fact, most cases that I handle, many spouses continue to reside together in the beginning of their divorce because they don't know the issues of what amount am I going to end up with? Who are the kids going to live with? And these are issues that we resolve during the divorce case. And sometimes the parties know no matter what, we can't afford to live here, and they end up selling their house and then moving. But the fact that you can't afford to live separately at that point does not prohibit you from getting a divorce. You can and should file if that's what you want.
Great. Okay. How can I force my spouse out of our home during the divorce? I'm sure this is a very common question. So is it possible? Can you force your spouse out of the house?
You can. There are 2 ways to separate pending a divorce with the court prohibiting you to continue to live together. The first is if there's issues of domestic violence. If there are issues of harassment, assault, any criminal conduct, threats, where you feel unsafe to continue to reside with your spouse, you can and you should call the police. The police and the court will help you apply for a temporary restraining order, which the court may grant. And as long as there's a temporary restraining order or subsequently a final restraining order in place, your spouse will be prohibited from living in the home. The other way is much less common, and it's under a case, Roberts v. Roberts. And basically, you have to prove to the court that it is, there's imminent danger of some manner to you and or the kids by your spouses continuing to reside together. So there may not be domestic violence, but there is a very good reason that puts you and your children in danger if you continue to reside together.
But what if it's just, well, I don't really like my spouse, we're getting divorced, I don't think we should be living together. Is there a way to get them out of the house?
Unless you have the money to buy them a new one. They're entitled to live in the house if it's joint marital property just as much as you are. So your much better bet is to amicably try and resolve who's going to stay in the home, or are we going to sell it?
That's a great answer. Okay, next question. Am I allowed to leave the marital home with my children, or would this be considered abandonment?
You absolutely can leave the home with your children. Again, I recommend speaking to your spouse before you do so, because if you leave with the children and your spouse does not agree, they can file an application before a judge and seek to either have the children return or to have some custody parenting time resolution. And so if you amicably agree to separate, that's better. If you have a custody and parenting time agreement in effect prior to the separation, that's the best scenario. Right. Abandonment is one of the fault grounds actually in the divorce statute, and it has no bearing on any equitable distribution, on any spousal support, so it doesn't matter who leaves and when you leave, but your best bet is to resolve who's going to be with the children when before you actually separate.
And this is a common myth and misconception in divorce law, that if you leave the property, you're abandoning it, you're giving up the equity in the property, and that's not true, is it?
Absolutely not. You hit the nail on the head. There is, you can leave and you're entitled to equal distribution of all assets that you earn from the date of your marriage to the date one of you files a complaint for divorce. That's the marital time, and no matter whose name it's in, and no matter if you currently reside in the property, it's still subject to distribution. Okay,
next question. My spouse cheated on me. Will that get me anything more during my divorce? Will it?
No. Again, we are a no-fault state. So even if you allege adultery, there is no impact with regard to spousal support or equal distribution. The only exception would be if your spouse cheated on you and ran up the credit card by doing so, and those expenses you wouldn't necessarily be obligated to pay for. They wouldn't be considered a marital debt. And so you could certainly argue that those expenses incurred in the relationship that you were not a part of should not be yours, but that's really the only impact.
So we're talking about things like a hotel room or a jewelry or a dinner, something like that.
Exactly. You shouldn't have to pay for those, but it has no impact on the money that you get.
Here's a similar question. Am I allowed to date during my divorce?
Absolutely. You can date, you can have a relationship. There is no prohibition on having a relationship once your marriage is dead. Just like there's no fault for adultery and for cheating on a spouse and having an affair, there's no reason why you can't date while you're getting a divorce.
Any tips for someone who is dating during the divorce process?
I wouldn't rush to introduce the children to the new person, because that could certainly inflame the situation.
Sure.
But you certainly are entitled to be happy and have a relationship outside of your divorce. Once you've both decided that you're moving on and your marriage is done, there's no reason why you can't pursue another relationship.
Okay, the next question. How long does it take to get divorced?
It's a hard answer because, unfortunately, it depends.
It's a very lawyer answer right there.
It is. Listen, if you and your spouse have an agreement or amicably agree on all the issues regarding your marriage, such as custody, child support, alimony, distribution of your assets and debts, you can have an attorney draft an agreement and get divorced right away. The "it depends" is because if you can't resolve it and you need to seek help from a court, it's going to be a long process, unfortunately. If you file your complaint for divorce in court and you're asking for a trial on the issues, which is really only 1 or 2% of all cases reach a decision by way of trial, then you're going to be waiting. It could be a year, it could be 2 years, depending on the complexity of the case. Unfortunately, the pandemic has not increased the productivity. It's had the opposite effect because many people work from home. There's a backlog. We also don't have enough judges, frankly, in New Jersey to handle all of the matters. So it's going to be a while. That's why it's so much better to resolve your matter than have to litigate. But if you have to litigate any issue, it could take time, and that's why there's no, at least a year if you can't resolve it quickly.
And it also matters what county you're in New Jersey, doesn't it?
It absolutely does. Counties vary how many judges are able to work on the divorce dockets, and some counties are overloaded and some counties are much smaller, and you can get right in and right out.
Right. Okay. I asked my spouse for a divorce and she said she doesn't agree. Can my spouse stop me from getting divorced? Is that possible? Can you stop a divorce?
You can't. A divorce will proceed no matter what. However, it is very typical where one spouse is ready and is ready for divorce, and that's when they tell the other side. And the other spouse may be shocked. There's emotional trauma. And typically, this happens all the time. And the spouse who didn't see it coming, which happens a lot, even if there were problems in the marriage. And so they could hold up the process. The process is not going to be necessarily expedient because you can't resolve the matter until you've come to terms with it. So while the other spouse can't stop the divorce from happening, it could prolong it if one spouse doesn't want to get divorced.
That's a great answer. Okay, is there a requirement that we attend marriage counseling before I am able for a divorce? Is this part of the process? Is counseling required?
It's not. It should be required prior to marriage, honestly. but it's not required after. You are not required to go to counseling. You may be required, if you're in the court system, to go to mediation, both financial and custody and parenting time, but you're not required to go to counseling.
Okay, one more question before our break. How long do you have to be married to get alimony?
There is no term. There is no specific term. Alimony is a payment made from one spouse to the other in order to attempt to keep both spouses in the marital standard of living. I like to say it's really an ability to keep both spouses in an equal deficit, inability to meet the marital standard of living.
Right,
because
exactly.
You have one house and now you have to have two. And that payment is an amount and is also a term. The term, if you're less than 20 years, would be sometime between half the length of the marriage and the full length of the marriage. So if that's 3 years, it would be between 1.5 and 3 years. And if it's 15, again, between 7.5 and 15 years. If you're over 20 years married, you can have what's called open durational alimony. And that alimony would be a payment until such time as the supported spouse remarries. They live in a relationship tantamount to marriage. One party dies, or there's been a good faith retirement by the payor.
Well, Stacey, you are a wealth of knowledge, and I'm just throwing these questions at you. More frequently asked questions with Stacey Cozewith after the break.
I handle all types of family law matrimonial cases, from prejudgment cases, people who come to me seeking a divorce for the first time, to post-judgment cases where people have been divorced already and have an agreement and we're seeking to enforce or modify that agreement. When people come to me, the first thing that we talk about is if there are children in a divorce. To me, that is the most important issue, as I know it's going to be the most important issue to any client who walks through the door who has a family. There's several different types of custody. There are two different legal types of custody. There is joint legal custody and sole legal custody. In most cases, it is joint legal custody. What that means is that they make major decisions together. We're not talking everyday decisions, but major decisions affecting the child. If you can't make those decisions together, there are several people that I work with to help parents resolve their differences in terms of both acting in the best interest. We can have parent coordinators involved, mediators involved, and I myself help parties going through divorces make decisions in the best interest of the children. There are also different types of physical custody. Physical custody is where the child actually sleeps and lays their head at night, but parties can have any arrangement that works for them and their family, and the court only cares about, and their sole overriding goal is the best interest of the child. You can have true shared physical custody where the child actually is with each parent 50% of the time. That could mean 1 week on, 1 week off. It could mean a schedule that I personally prefer more, where you have Monday and Tuesday with mom, Wednesday and Thursday with dad, and then Friday, Saturday, and Sunday are alternating. Or any other schedule that works for the parents given their work schedules and their other obligations. My children are obviously the most important thing to me, and I know that clients coming in the door who have children, that's the most important thing to them. And so I do my best to help parents figure out as efficiently, quickly, amicably a custody resolution. It is extremely emotionally exhausting to fight and to deal and litigate custody. I do it all the time, but we try and avoid it at all costs. It's the last resort.
Welcome back to Legal Breakdown, where we break down legal topics to make the law relevant and accessible to everyone. I'm your host, Erin Brueche. I am here with Stacey Cozewith, who is answering all the frequently asked questions about divorce and family law. And we were plowing through before the commercial break. So I want to get to some more frequently asked questions because I love this topic. Okay, you ready, Stacey, for some more?
I'm ready.
Okay. I gave my spouse a 3-carat engagement ring. Is it possible to get that back during my divorce?
Well, you're very nice in giving a 3-carat engagement ring. It sounds pretty nice. Unfortunately, the answer is probably no. An engagement ring is a gift conditioned on marriage. It's a conditional gift. So once the marriage or the condition is fulfilled, it's a gift. So if you had broken up prior to the marriage and you had given an engagement ring, you would get that back because the condition had not been fulfilled. But once you're married, the condition's fulfilled and it remains a gift from one party to the other.
Let me change the facts slightly. What if the ring, the diamond from the ring, belonged to the husband's grandmother? Does that change your answer?
You could term it as an inheritance, but it's still a conditional gift. The best way to resolve it, I believe, is to appeal to your spouse and to work with them. Maybe you agree that this engagement ring is going to be passed down to your mutual children in common, and that you save that because it is a special family heirloom, or likely it's a give and take, right? If a court may not award me, a court may award me it, and maybe I give you something else in exchange for getting that ring back. There's a lot of usually assets in a marriage, some smaller, some larger, and that could be one of the assets that, part of the overall global resolution.
Right, a whole bargained for agreement, and you can trade things back and forth. That might be one of the things you got to give up to get the divorce settled.
Absolutely.
Okay, I've been married for less than a year. Can I get an annulment?
You can. So an annulment is different than a divorce. An annulment is basically saying the marriage never happened. So an annulment can be void or voidable, and a marriage could be void or voidable, and that's an annulment. So a marriage would be void if it were illegal at the time entered into.
Okay,
so
for example?
Right, so for example, incest. One party was still married, or one party was not of legal age. So in those circumstances, the marriage can absolutely be void and be annulled. A marriage could be voidable, and you can still get an annulment if, for example, there was fraud, if there's impotency. You'd have to, if what person was not of sound mind. So, for example, if I got married and my spouse said he never wanted kids, even though when we were dating and married, he absolutely proclaimed his desire to have children, I could claim that was fraud and seek an annulment. If I was coerced into the marriage, or if I claim if the person is institutionalized and not of sound mind, then the marriage could be voided.
But does the time you were married have anything to do with the annulment? Let's just say it was two young kids, they decided to get married, and they decided 6 months later that was a mistake. Can you get an annulment under those circumstances?
Well, it wouldn't be void unless one of the examples that we gave, if one of the parties was already married, if one was too young to actually be legally able to enter into a marriage. If it's just, I didn't want to have a marriage, unless there's fraud or coercion, or like I said, impotency or unsound mind, you really cannot get an annulment. You'd be in a divorce situation.
Right, so you're just looking at a regular divorce and it's a really short-term marriage.
Right.
Great. Okay. What is the difference between a contested and an uncontested divorce? What does that mean? Because you hear those terms a lot.
A contested divorce would be without an agreement. An uncontested divorce is where you have an agreement as to all issues incident to your marriage and your divorce, on custody, parenting time, child support, alimony, equal distribution, counsel fees. Everything is resolved, and then you can apply and say, Judge, I have an uncontested matter, and they will grant you a divorce. A contested case would be where you don't have an agreement and you're still trying to resolve it, and or you're asking the court to resolve it for you.
Well, then aren't all divorces contested when they start because there's no agreement on anything?
Not necessarily. The best way for people to get a divorce, I believe, is to have everything resolved prior to even filing the complaint. So if you came to me as a person who needed a divorce, I would do my best to try and amicably resolve the matter prior to filing anything. Once you file a complaint for divorce, you have to file documents, you have to do mandatory court appearances, so you're spending time, you're spending money, it's emotionally draining.
Right.
When you may not have to do that, you may be able to resolve it either directly through attorneys, directly through the parties, or using mediation or arbitration before you even say to the court, I want a divorce.
And that's a great way to end a marriage too, something amicable and something that can be done quickly without too much fighting, and to preserve your co-parenting relationship for your children.
Absolutely, it's definitely the ideal way.
Great. Okay, next question. My spouse is threatening to stop paying our household bills. I'm a stay-at-home mother without a job. What are my rights? That's a great question.
It is, and unfortunately a situation that a lot of people find themselves in. If you have a spouse who isn't paying the bills, then you could petition the court to file a motion to seek that they be obligated to continue what's called the marital status quo. So both parties, when a divorce is pending, are required to maintain the status quo, or what they did prior to the divorce being filed. So if both parties had certain obligations, usually one party takes out the trash, one party puts cooks dinner. Usually
Right.
You divide obligations, right? So, in this circumstance, the wife is a stay-at-home mom and she took care of certain obligations, and the husband did as well. And so he's going to be required to comply with those obligations and continue those obligations, and that's the status quo.
What if, let me take it a step further, what if I'm a stay-at-home mom and my husband has cut off my credit card, closed our joint bank account, and I have no access to money? What do I do? How do I even hire a lawyer? You can seek legal representation. You can go through legal services or find an attorney who's willing to take on your matter, depending on the size of the estate, or maybe you can borrow money from friends to hire an attorney to file an emergent application with the court
in order to get your husband to, maybe there's money in a certain account that you can get money from, or you want his wage garnished if he is a W-2 employee.
Right, there's a great option right there.
Right.
To get the money and take it right out of his account.
Right, so you definitely have the ability to seek relief from the court, and the court will grant it to you.
Great. Okay, can I take my spouse off my medical insurance? And what about my car insurance? So how does insurance work during a divorce?
You are required to maintain all insurances pending litigation. That's home insurance, vehicle insurance, medical insurance, life insurance. You can agree. You can say, listen, you have the ability to maintain your own medical insurance. I'm going to remove you from mine. It's my window in which I can change it with my employment. And if the other side agrees, that's fine. You enter into a consent order, an agreement saying that you can do that. But absent agreement, you have to maintain all insurances pending a divorce.
Now, what if someone takes the other person off the insurance and they found out after the fact, and let's say it's a medical insurance policy and the spouse has been removed, and then the employer says, well, open enrollment is over, I can't add them back. What happens then?
Well, first of all, you want to obtain insurance quickly. You can do so if you can't through your own employment. You want to obtain insurance, you can do so through New Jersey Kid Care for your children. Second of all, you need to be made whole. And so you would contact your attorney, and if you had to, file an application with the court for the spouse who terminated the insurance to either put you back on insurance, via court order, they can do that, and to reimburse you, make sure that they have the responsibility to pay for the fees that you wouldn't have had to pay for, but for their recalcitrance. And in that situation, I believe a court would probably award counsel fees as well.
When you say award counsel fees, what does that mean?
So counsel fees are awarded by a court when requested based upon good faith, bad faith, ability to pay, and need. There are several other factors, but those are generally the main factors the court looks at. So bad faith would be, but for his actions of taking you off insurance, you wouldn't have had to come to court. You wouldn't have had to incur this expense. That's bad faith.
Right.
You had good faith, you tried to resolve it, maybe you sent a letter before filing the application, and they exhibited bad faith. Need and ability to pay, especially in our prior circumstance where the spouse who wasn't working, that's a need. And if there's a spouse who is working, they would have an ability to pay.
Absolutely. Absolutely. Great answer. Do I have to split my retirement account during a divorce? And how can I avoid paying penalties and taxes? What's the deal with retirement assets?
The good news is that all assets split pursuant to a divorce, or we call it equitable distribution, there's no tax consequences. So, said differently, there's no tax consequences because of your divorce. Clearly, if you sell a property, you're going to have to pay taxes on it jointly as anyone would. But if you're transferring money from a 401k, let's say, and you're rollovering part of it to an IRA, there's no tax consequences with that. You will have to divide your retirement accounts. So the monies that are subject to distribution between your spouse is anything earned from the date of your marriage to the date of complaint for divorce, or you otherwise agree on an end date. That marital, we call it the marital coverture, that time that you were married and what you earned is subject to division between you and your spouse.
And is that always 50-50?
It's not always 50-50, but passive assets such as retirement accounts, bank accounts, real property, things that increase in value based on market fluctuations, those usually tend to be 50-50. Our statute is equitable distribution, not equal distribution. So that means that there's many factors that the court would consider as to what's equitable. Those include time, both spouses' need, ability to pay, time away from the workforce, who put the money in. For example, if you're selling a house and you recently purchased it and one party used $300,000 of their premarital IRA to purchase the house, that would be taken into consideration as long as the purchase was recent in time to when you distribute. Maybe they would get all of the $300,000 back, maybe they wouldn't, but it would certainly not be a 50-50 split. And so, it depends on many factors.
Right.
So those are passive assets. Active assets, such as if I owned a business, that wouldn't necessarily be 50-50. An active asset increases in value because of my work efforts.
Right.
As opposed
what you're
to
doing.
just,
Yep.
right, as opposed to the market fluctuation. So that would be less than a 50-50 split. This meaning the spouse who did not own the business and who did not increase the value with their work efforts, while they certainly did help the other spouse, maybe by entertaining clients, allowing them to do that while they took care of the children, they would still be entitled to a significant portion, but it's unlikely to be equal.
Oh my goodness, Stacey, I have so many more questions, but we're all out of time for today. So you're a wealth of information. Look over there and tell the audience how they can find you if they can use your services.
Thank you, Erin. It's been a pleasure. You can find me in my law firm is Snyder, Sarno, Daniela, Massarian, DaCosta. My phone number is 973-274-5200. It's snydersarno.com and scozewith@snydersarno.com.
Stacey, thank you for coming on Legal Breakdown. This was a great show. I have so many more frequently asked questions to get to, so you'll have to come back another time. That's all the time we have for today. Catch us next week for another episode. We'll see you then.